Okay, welcome back. We are here again on Wednesday morning with let's switch our gear over to S-102 to the full bill. And the first testimony that we will receive is up on Zoom. So Damien, we're going to be looking past you. While we hear from Caroline Gordon, who's the Legislative Director for Rural Vermont. Caroline, welcome. We'll go around the circle here to introduce ourselves. The first time you've been in our committee. So I'm Representative Tom Stevens from Waterbury, representing the Washington Chittenden District, chair of the committee.
Representative Robin Chestnut Tangerman from Rutland Bennington District.
Good morning. I'm Representative Mary Howard from Rutland City District 6.
And I'm Larry Lieber. I represent Orleans, Essex, District 1.
Good morning, I'm Elizabeth Burrows, and I represent Windsor 1.
Good morning. I'm Representative Dennis LaBounty, and I'm from Caledonia 3.
Representative Caleb Elder from Addison 4.
Ashley Bartley, Fairfax, Georgia.
All right, and so we have several people who may come in and out as the morning goes on. But Caroline, we've taken up S-102, which is an union organizing oriented bill, and there's one section in here, I believe it's section 2, that has one seemingly small change in it, or two seemingly small changes in it, and that would be to remove agricultural laborers from the exemption list in terms of employees who can organize and are given the right to organize. And you expressed a desire to testify on that, and so welcome.
Yeah, good morning. Thank you, Mr. Chair, and nice to meet you all. Thanks for the introduction. Thanks for having me this morning. I know you also had a kind of longish evening yesterday. So my name is Caroline Gordon. I'm Rural Vermont's Legislative Director, and I live in Tunbridge, Vermont. I was born and raised in Germany. I'm a German American and a beginning sheep farmer in Tunbridge, Vermont right now. So Rural Vermont was founded by farmers in 1985, and today we're one of Vermont's largest farmer membership-led nonprofit organizations. We do organizing, education, and advocacy on a variety of priorities such as agroecology, ban of neonicotinoid-treated seed, on-farm slaughter, a fair and equitable cannabis market, and we're also represented in the Vermont Conservation Strategy Initiative, or the 30 by 30 process. So we are a small part-time staff, and as such, very limited in our own capacity. So we explicitly want to appreciate all the good work on S-102 and Proposal 3. And I'm here today to read a short statement on behalf of Rural Vermont in support of these initiatives. And I will read that now. I also submitted that earlier in writing to the committee just this morning. So the right to unionize is foundational for the ability of historically marginalized farm workers to organize in unions that improve the protection of the rights of workers in Vermont. S-102 would bring important checks and balances to workplace environments across Vermont. Rural Vermont envisions a just and equitable world rooted in reverence for the earth and dignity for all. This abundant and generous way of life celebrates our diversity and interdependence, in which communities of microorganisms, animals, plants, and humans tend to one another and nurture generations to come. Please support the passage of S-102 as it includes important protections for farm workers and domestic workers' right to unionize by holding employers of farm workers accountable if they prevent farm workers from organizing or discriminate against workers who organize. With S-102, Vermont would side with Connecticut, Maine, I think it's Minnesota, New Jersey, New York, and Oregon, and fix in state law the continued exclusion of farm workers from the protections of the National Labor Relations Act of 1935, which forbids employers from firing workers for joining, organizing, or supporting a union. S-102 also sets important boundaries for employers that would protect workers against misinformation, especially in regards to their own rights. please endorse S102 and also Proposal 3 that would enshrine the right of Vermont workers to organize and collectively bargain in the Vermont Constitution with your vote. So yeah, thank you all so much for your time, and I'm also happy to answer any questions if there are any.
Representative Chestnut Tangerman, Bill Burrows.
Thank you. And I'm wondering if you could just say again the names of the states that have already adopted this, and if you know how that has played out in those states, what have the effects been there? I mean, has it been utilized? Is it an opportunity waiting to be utilized, or?
You know, I'm really not the expert to speak to how it played out, but the states that I was informed that already have passed similar initiatives are Connecticut, Maine, Minnesota, New Jersey, New York, and Oregon. And I will also put that in the chat.
Okay. And I will ask other people how it has played out, what the effect has been. Thank you.
Representative Burrows.
Thank you. I wondered if you could talk more about the protections against misinformation.
So I think the fear there is that these captive audience meetings could be utilized to share information about workers' rights in a way that's more or less not appropriate at times. And so that that section in the bill that would kind of prevent these kind of captive audience meetings from happening would thereby create a layer of protection from misinformation to be like forcefully spread amongst workers.
Thank you.
Caroline, with respect to agricultural workers, I'm sorry, the current statute says agricultural laborers. And I have, just a question on language and in terms of farm, I mean, we could say that's a farm worker, but from rural Vermont's perspective, is it a larger class of people, I mean, that have been excluded in our current law? Is agricultural worker being a cheese maker? Does it make agricultural products? We still have time to find out a closer definition, but agricultural worker, we've been making that equal analogous with just farm worker. And I'm just curious if rural Vermont has a finer definition of what that might mean.
Thank you so much for the question, dear Chair. That's something I would maybe take home and think about with staff, and also make sure to look into the terminology if there is a definition. I'm not sure, I don't know that off the top of my hand. It does seem to me that the term agricultural is broader than farm worker specifically, so that seems already to be a broader bracket that is applied here. But if it should be even broader through a different terminology to make sure all the manufacturing and processing sectors are included, that I would need to think about and consult potentially with other organizations too.
I appreciate that. And you can certainly share any of that information through our committees if you like, or further questions for Caroline? No, thank you so much for your time. Wanted to be able to allow you to, and thank you for requesting time to come in and participate. Much appreciated. Feel free to stick around if you'd like to hear the conversation. We're going to start having some conversation about S102 on a section by section basis and start getting one. At this point in our work, we tend to try to get those clarifications so that we understand and not to make assumptions that an agricultural worker, in this case, an agricultural worker may only be a farm worker, or if it's a larger class of people. And I think some of that we have our legislative counsel here to take us through some of these, some of this work. So thank you for your time.
Yeah, and I'm happy to stick around and listen in also legislative council might be able to reveal on the terminology piece. And if there still remains a need to look deeper into that, I'm certainly happy to circle back should that be the case.
Great, thank you. All right, Damien, welcome back. Before we start at the beginning, just a question on this exemption in law for in this case, agricultural workers and domestic workers, because it's not focused solely on agricultural laborers is dismissing the fact that also domestic workers are have been deleted from this exemption list as well. So these exemptions are, first of all, tied into the legislation that was passed in the 1930s. These exemptions also play out in wage conversations, the same exemptions. Can you explain, like, we were asked, I believe yesterday, or it came up in conversation or through testimony, like, can the state of Vermont make a change to these exemptions?
Yes. So, for the record, I'm Damien Leonard from the Office of Legislative Counsel. So the National Labor Relations Act excludes certain categories of individuals from its coverage. The first is individuals who are covered by the Railway Labor Relations Act, or I think that's the right word, the RLA, which covers workers on railroads and airlines. And then the second are public sector employees in the states. And so that's our state employees, judiciary employees, municipal employees, labor relations acts, which we've been discussing. And then the third and fourth are agricultural workers and domestic workers. So those are the four big categories. To date, just to follow up on our witness's testimony, there are, according to the National Ag Law Center, and I have not independently verified this, Arizona, California, Colorado, Hawaii, Kansas, Kentucky, Louisiana, Massachusetts, Nebraska, New Jersey, New York, Oregon, Washington, and Wisconsin, so 14 states, provide some form of collective bargaining rights for their employees. And this may be dated, but it's roughly 14 states. There are limitations in some of those states on things like strikes because of perishable goods or seasonal periods when strikes would be catastrophic for a farm. So, for example, Arizona limits the right to strike because of the seasonal and perishable nature of agricultural products. Oregon bans picketing at places where perishable crops are produced if the crops are currently being harvested. Wisconsin requires a 10-day notice to the labor board or to their Employment Relations Commission to prevent harm to agricultural products. So there are things like that that are unique, but it is not definitely far from unheard of for states to permit agricultural workers to collectively bargain. And it's simply because, and this is gonna get complicated later when we start talking about preemption, but Congress chose not to act here, but they also chose not to simply prohibit bargaining by these groups of employees. So when they enacted the NLRA, they could have said, anyone who's not an employee shall have no right to collectively bargain. They didn't say that. They just said, for purposes of this act, these are the employees who are covered. States, you can do what you want with the rest. And so that's been a long-standing balance between state and federal authority. So federal law covers those workers in railways and airlines, and then most employees in interstate commerce. State law can cover, but doesn't have to cover, public sector workers, ag workers, and domestic workers.
So if we take away this exemption in our law, does that mean that how would a group of farm workers then organize?
So-
If we do not have statute on our books that would allow that.
So they would actually fall under the existing definition of employee. So if we look to our existing State Labor Relations Act. Let me just pull this up. Share my screen. Once I've got this up. So as you'll see, what it provides is that employee includes any employee and is not limited to the employees of a particular employer unless this chapter explicitly states otherwise, and includes any individual whose work has ceased as a consequence of or in connection with a labor dispute, or who has not obtained any other regular substantially equivalent employment, and who has not obtained any other regular and substantially equivalent employment. But the important piece here is includes any employee. And then, but does not include an individual. So currently we list these other individuals who are not included. Employed as an agricultural laborer, employed by a parent or spouse, domestic service, independent contractor, supervisor, employer covered subject to the Railway Labor Act, or employed by any other person who is not an employer. So what do those exemptions mean? The first, agricultural laborers, it means any employee who doesn't work on a farm in agricultural production. That's generally what agriculture has been defined to include. For purposes of the federal act, the NLRA's exemption has roughly been defined to be as broad as the FLSA's exemption for agricultural labor. So it includes the production, the primary production of food crops and fiber crops on farm, as well as livestock production. So that can include honeybees, as well as things like raising cattle, sheep, whether that's for food or fiber. So whether you're herding sheep for their wool or you're raising them to produce lamb and mutton, doesn't matter for purposes of the act. Employed by parent or spouse, it kind of makes sense. You don't want to dictate family relations through a collective bargaining act overseen by the labor board.
But wait, you're not my boss. You're not the boss of me.
My kids aren't even teenagers yet, and I get that. Employed in domestic service. This is one that there aren't many houses in the US that still have a domestic staff of more than 5 or more. But to the extent that they are, historically, this has been excluded. I don't know the extent to which other states have eliminated this exclusion and allowed bargaining, or the extent to which, if they have, you've seen people bargain.
Sorry, 5 or more, that's part of the, underlying process
That's in the definition of employer here.
Yeah.
So in order, you have to have, for collective bargaining, you have to have an employee-employer relationship. So even if you fall under the definition of employee, if you don't work for someone who falls under the definition of employer, you don't fall into the jurisdiction of the law. Independent contractors, go ahead.
Clarification.
and then the rest of the
So we talked about like municipal employees and the 2 members of road crew being able to collectively bargain. Like, would that require the town to have 5 employees?
Yes, and they would have to be, potentially they would have to be in a bargaining unit with the other employees, but that's something the labor board determines. So, for example, it definitely doesn't make sense to have collective bargaining when you have 1 employee in a bargaining unit. That's just the employee talking to their boss. Yeah, there's no collective. The labor board determines the appropriateness of bargaining units. And typically there is a threshold below which a bargaining unit gets so small that it doesn't make sense to have collective bargaining. It adds more complication to the process than it actually, eliminates in terms of providing a way for employees to get together and make a collective statement, and for an employer to get the benefit of not having to bargain 15 individual contracts. So, oh, yep.
Real, I always say real quick and it never ends that way, but hopefully this is real quick. So is it possible that, because you said they have to qualify as an employer role in order for it to be valid, but is it possible to not meet the employer requirements and still have 5 or more employees? Like, how would, like, is that a possibility to not make the
Yeah.
employer requirement?
So you'll notice here, one of the things that one of the groups we've singled out is the United States. So the federal government definitely has more than 5 employees, but they are expressly not covered by our collective bargaining act because we don't have jurisdiction over them. Likewise, for purposes of this bargaining act, the state and all of its political subdivisions, so municipalities,
Right.
et cetera, are not employers for purposes of this act, even though many of them have more than 5 employees, and especially the state where we're talking several thousand employees. But this is not unusual for employment and labor laws to start whittling down who's actually covered through a variety of different, I like to think of them as you're an employer if A, B, and C, but you're not an employer if you only meet A and C.
Yeah.
You don't satisfy B.
Yeah.
So same thing for employees. So we've said this in the past for other acts, and sometimes it's you're an employee if you are, any one of the following 7 things, but sometimes it's you have to meet these 3 requirements to be qualified for the act. So that's not unusual. In this case, you have to meet the definition of employee and you have to have an employer that's covered by the act. That's the way to think about it. There has to be an employee-employer relationship that the act covers. And that's sometimes there's an employee-employer relationship, but the act doesn't cover it. Sometimes you're not an employee. Sometimes the person you want to bargain with isn't your employer. So.
See, that wasn't so bad.
So just to be clear, domestic service is domestic service defined someplace in our statutes? Is that?
It is not expressly defined. Domestic service is understood as the services traditionally provided within the domestic sphere. So this would be, if we want to go Downton Abbey, your valets, your footmen, your maids, your cooks, your groundskeepers, et cetera. But realistically, in modern United States, this could include a cook, cleaning person, nanny or other caretaker for your children, or a caretaker for adults who have needs for caretaking during the day. So those are the folks here. It could also include folks who take care of your property, although very likely they are either independent contractors
Right.
or employed by an independent business. There are very few homes in the United States that have dedicated groundkeeping staff employed by the house, rather than employing a landscaping firm that might have half a dozen employees and a couple of trucks that go around with their trailer, and they hit your yard for 30 minutes and then they go to the next house down the street.
Which, so S102 is proposing to delete A and delete C,
right?
and then to make a change in F where it says as amended from time to time, is that just a technical?
Just, yeah, as amended from time to time is really unnecessary and duplicative language, because if you just say subject to the Railway Labor Act, that means the Railway Labor Act as amended from time to time. So we use this language traditionally when we would refer to, for example, the Wagner Act of 1935 as amended from time to time, which would then bring into it the Taft-Hartley Act and other acts that have amended that what we know as the National Labor Relations Act. Simpler way to say it is just subject to the National Labor Relations Act or the Railway Labor Act, where we just refer to the general thing instead of referring to, it's like if we referred to session law here at the State House, then if you want to keep that as it gets amended, you have to say as amended from time to time, or better yet, just refer to the section or chapter of statute, because then you encompass all the amendments that happen to that over time. So, yeah, so we're just getting rid of extraneous language there.
Representative Ladon.
Just for clarification, when you said that you need 5 or more to be in a bargaining unit.
No, that's for the employer to be an employer. Bargaining unit number is determined by the labor board. They may say 2 employees, that's too small a bargaining unit, but they could theoretically approve it.
Because the reason why I'm saying this, and I don't know how they did it, but in the granite industry, there's a lot of little sheds. 1 employee, 3 employees, 2 employees, but they're all underneath a master agreement. Is that,
Right.
is that the main,
So
that's the main reason why they're able to do that?
Yeah, so that can happen too, where you have one sort of parent company, or potentially an agreement between multiple employers.
Yeah, that's what this
So you
is.
can have a multi-employer agreement where, for example, you have multiple employers who produce a very similar product, have similar employees, and the employers have agreed among themselves to bargain with all the employees collectively. So the benefit for that for employers is they take the competition element out of it. So they're not dealing with the guy 30 yards down the street poaching their staff. And the benefit for the employees is they know they're able to bargain together and ensure that they're all getting similar benefits, and that no one's getting taken advantage of because they don't know what to ask for, they're new to the industry, et cetera.
All right.
And they can ensure that things like seniority and experience are recognized in a sort of structured way. And they can bargain together for certain protections, which would, and they have the power there to literally shut down the industry in an area if they decide to go out on strike. So they gain considerable bargaining power that they wouldn't have if it was just them and their employer, who could say, especially if they didn't have that multi-employer agreement, and the employers gain the confidence of knowing they're not going to lose their employees to someone else who decides to poach them by offering something they're not.
I knew there was a catch in there somewhere.
There is. So with everything we're going to be talking about today, I'm going to try to make it simple. This can get as complicated as you want it to be, and possibly more complicated. So for example, with preemption, we're only going to talk about 2 types of preemption. Preemption is a doctrine that you could literally spend a semester of law school studying and still not understand fully. I know for me, I still am learning things about preemption, and I've been practicing law for 15 years. And I spend a lot of time working on it in this building. So with respect to the ag workers, though, we can give them collective bargaining rights. The important thing here is we don't need to define agricultural laborer if we take it out of the exception, because it says any employee. And we have not excluded agricultural employers from this. Some other states have added express language. So for example, well, California, they enacted an entire Agricultural Workers Labor Relations Act. New York State simply updated their law to say that the term employees, they struck out the exclusion for farm laborers, and then they added an additional section saying the term employee shall also include farm laborers, which shall mean any individual engaged or permitted by an employer to work on a farm, except the parent, spouse, child, or other member of the employer's immediate family. So in this case, we already exclude parent, spouse, child. And if you say any employee means any employee. So adding that language, you could do it. It's belts and suspenders. You don't need to do it.
All right.
Do you want to turn back to the bill?
Well, we just did section 2, so we can go back to section 1 and then on to the section 3 and so forth. But so section 1 again is starting at the beginning. Actually, before I do that, is everybody okay with where we are with understanding what section 2 is about? And just the last clarification I would have for that, Damon, before we move on, is it's any employee. So if a group of farm workers, cheesemakers, food industry individuals in the production of food, choose to organize, they would go through the same process that exists for anybody else. They would go to the Labor Relations Board, the National Labor Relations Board, if it's
Be state in this case for the ag workers.
because
Because,
it's state law,
right,
and they're not contemplated under federal law.
federal law expressly.
Right, so they would go to the Vermont Labor Relations Board and says that this particular union is going to be our exclusive representative. We need to know what our bargaining units are. They go through the same process anybody else goes through, determining what bargaining units are going to be, whether or not the Labor Relations Board is going to approve that particular bargaining unit, and the steps up the ladder to becoming organized are would become the same as anything else.
Exactly the same as any other bargaining unit. So that, yeah, it'd be the petition, and then a period of time before the election, and then an election. And then if they get the majority in the election, they elect the union represents them, and then it has to negotiate a first contract with the employer. And then after that, the contract takes effect, and you're functioning the same as any other unionized workforce in the state.
For just last, we had testimony yesterday from Migrant Justice. Does this apply to undocumented workers, people who are not citizens of the United States?
So this does not exclude non-citizens. Employee is not defined based on having federal work documentation or anything like that. So that said, I can't guarantee how the labor board would rule on that issue if it was challenged. There have been challenges in the past to undocumented workers' employment rights under federal law, and you've gotten sort of a mix of decisions. In some cases, they've been protected, in other cases, they haven't. But at this point, I would say the statute doesn't exclude undocumented workers, agricultural workers, so arguably they could unionize. So I don't think there's a need at this point to clarify that it's regardless of whether they have federal documentation. You could certainly add that, but there's nothing in here that excludes them.
So I may ask you this 3 more times as well.
Okay,
since I seem to be fairly dense around some of this. But interstate commerce is preempted by national labor relations.
yep.
And in something like dairy, it's an interstate.
So, yeah, think of the NLRA this way, the National Labor Relations Act. It covers all the employees that it covers, all the types of employees that it covers, if they're working in interstate commerce. That said, I work for state government, but the work I do affects interstate commerce. Same as someone who works for AOT, BGS, DMV, ANR, everybody in state government affects interstate commerce. Because we're buying products in interstate commerce, we're affecting trade within the state. We're doing business with corporations from around the country. However, because we're excluded from the coverage of the NLRA, the state can govern our collective bargaining within the state boundaries. So the same would apply for agricultural workers and domestic workers, even if they're in the stream of interstate commerce, because Congress declined to cover them and expressly excluded them from the coverage. They left it to the states in this case to cover them.
And so for our purposes, is a milk processing plant, would that be manufacturing as opposed to agricultural?
Yeah, so let's take the Cabot cheese making plant or something like that, which is actually part of Agrimark. So, and I mean, like so many of our Vermont Creamery, I believe, is part of Land O'Lakes, et cetera. Those are, either way, those are not primary production on the farm. So they're bringing in milk and turning it into a finished product. I believe that is covered by the NLRA. I'm not 100% sure, but I believe that they're covered by the NLRA. So, and I think generally what you're looking at is if you're milking the cows and processing the milk on the farm, that is farm employment. Once you've handed it off to that intermediary to transport to a larger production company, it's now an interstate commerce. It's not the primary production. So there's a difference between, for example, the farmer doing things like picking strawberries and packaging them and putting them at the farm stand versus picking strawberries, which are then loaded onto a truck and sent to a plant where they're cleaned and pared and frozen and then packaged for sale at supermarkets. So that plant there is not doing primary production. That's sort of like secondary food production, if you kind of get that sort of level. So like primary, think of it as like the basic stuff on the farm. But I think if the farm is making incidental agricultural products on site, I think that's covered under primary production, but it gets
And if
it
there's
gets
a question, it would be
complicated.
determined by the.
It's going to be determined by the labor board. So if there's a dispute over whether something should be under national or state, our state labor board would decide if it has jurisdiction. And then if there was a disagreement over the state's jurisdictional decision, people are free to petition the courts to settle the issue. And then they would take a look at that. But I imagine our state labor board, if it's on that line between state and federal jurisdiction, is going to be looking at where is the NLRB exercise jurisdiction. If we're falling into that bucket, we're going to say, nope, you need to go to this is federal jurisdiction. But when we're talking, work on the farm itself, our national federal law doesn't cover that at all. So it would really be at the big production plants where I believe it falls under the NLRA. So
Thank you. Now, what if, some farmers like ones that grow corn or strawberries, local farms, and they themselves deliver it to the stores? Would that be considered?
I believe that is still the primary production of the farm.
Okay,
I apologize, we are getting into the sort of limits of my knowledge.
okay.
And so I think that is covered as primary production. But I am not 100% sure, and I don't want to muddy the waters too much by trying to speculate about where that limit is. The key thing is that work on the farm is not covered by the National Labor Relations Act. And I can try, if we have a short break, I can try to get you a better answer on that, or do it by tomorrow. But for the moment, I'm not sure exactly where they've drawn that line, and I can find that out for you.
And also just a reminder that this conversation is like going to, just, and we're doing our due diligence on some of these things. Sorry, Damien, are you sweating?
Okay.
So, yes, let's now turn our attention to section 1.
It's just a simple little bill, right, everyone?
That passes.
It only does 3 things.
It's only 12 pages long.
Um,
But I wanted to start with this because this is a clear example of removing 1 or 2 lines and what it means. It's not, it does change something immensely. It's one of those Jenga pieces that I keep talking about that if misinterpreted can, or mispulled can, not, some people feel like it's gonna knock the whole thing down, and other folks are gonna say it's gonna make it stronger. So I just wanted to spend some time on this section because we hadn't really previous to this conversation, and I know that we'll come back to it for further discussion later. Over the next couple of weeks. But I just wanted to make sure we got that out of the way and we didn't forget about it, put it into play, let people hear about it and testify. So that we're not surprised by it when we're ready to vote. Something like somebody said, hey, what about this section? But that's not the case for the other 2 sections. And so I just want to spend the next chunk of time on section 1, which is the captive audience meeting. We've heard testimony back in January and this past week. Again, the general gist has been the balance of the conversation has been captive audience meetings are either an expression of free speech. They are requirements for employees to come regardless of what's said in the meeting, pro, con. These things are defined, which we'll go over. What political matters are, what religious matters are. We'll be clear on what exactly is in the bill. And the question here for us is, is to get a clear understanding of what exactly this section says from council's interpretation of the bill, which he wrote. And as opposed to, in addition to, not as opposed to, but in addition to the testimony that we've taken on the interpretation of what this language may mean. So with that, let's begin at the beginning.
Okay, so section 1 here would prohibit an employer from discharging, disciplining, penalizing, or otherwise discriminating against or threatening to do any of those things to an employee because the employee declined to attend or participate in an employer-sponsored meeting that had primary purpose of communicating the employer's opinion about a religious or political matter, or to view or participate in communications with or from the employer that have the primary purpose of communicating the employer's opinion about religious or political matters, or as a means of basically coercing the employee into either attending such a meeting or participating. or viewing such communications. Before I go on to the exceptions, let's just talk about the definition of political matters. Means matters relating to political affiliation, elections for political office, political parties, legislative proposals, proposals to change rules or regulations, and the decision to join or support any political party or political, civic, community, fraternal, or labor organization. And religious matters means matters relating to religious affiliation and practice, and the decision to join or support any religious or denominational organization or institution. The part of this that has been most controversial is the issue of the decision to join or support any labor organization. That said, there are arguments about some of the other parts of it too, but that's been the greatest source of controversy. So questions about what's prohibited?
What about an organization that during an election, like an election year, each employee has access to a forum that has every political candidate?
So basically, the organization invites in all of the candidates to speak at a forum.
No, I know an organization that during an election year kind of has it's like an online forum. So it's like not a meeting, but they just say, you can type in your name, where you live, or like you can type in where you live, and it will show you who's running for office.
Okay, are employees required to
No, they're not.
participate?
They're not, but each employee is put into this database. So each employee is made like a username.
Okay. Does it convey the employer's opinion about who they should vote for?
No.
I think it violates this.
Okay.
Yeah. I think it sounds like the employees are in the system, but whether they utilize it is voluntary.
Yeah.
And the employer is not saying, for example, to the employee, oh, you're in Chittenden,
Yeah.
3. This is the candidate we support there.
Mhm.
Please acknowledge that you viewed this.
Okay.
So like that sort of thing.
Yeah.
That's where this draws the line, is requiring employees to view or participate. So for example, another thing would be, tell me who you're voting for.
Yeah.
That would also be something like basically having your employees tell who they prefer for an election.
Yeah.
Would be required participation in that forum, which again would be prohibited. But as long as it's just, here's the information,
Mhm.
you've got a username, you can access this. We're not telling you who to vote for. We're not tracking who you're voting for. We're not requiring you to do this. You're okay.
Yeah.
I think it gets muddier when it starts to be mandatory participation if the employer is expressing their opinion.
Secondary question.
Okay.
What if an employer says, giving you the day off to vote?
Mhm.
I'm not telling you you have to vote, but I'm going, if you like bring in an I voted sticker, I'll give you half a day off. Or like, does this talk like carrots were sticks?
So it's not expressing the employer's opinion
Okay.
on the political affiliation or a political issue.
Mhm.
So I don't think that's a problem there. It's simply saying on a neutral basis as an employer, I'm encouraging my staff to vote and we're providing a benefit for you to be able to engage in the process
So then.
versus saying you,
Yeah, but in these meetings, so say there's, an employer's not going to say, you're gonna get terminated, you're gonna have a write-up if you don't come to this meeting. But what if the individuals who do choose to go there then receive some sort of award?
That's getting into discriminating.
Yeah, okay.
So if you're basically giving individuals a bonus for coming to the meeting where you share your opinion on a political issue, that means the individuals who choose not to come are being treated less.
Okay.
Less well, and that gets to discrimination. So, yeah, carrots can be as coercive as sticks.
Yeah.
Depending on how they're used.
As the broadest possible stroke, is it fair to characterize the first part that it's not about what somebody says? It's not about limiting speech, it's about retaliation? Clear cut.
It is about mandating. It is prohibiting mandating that employees listen to your speech. So it does not necessarily limit what an employer can say, but it is putting restrictions on their ability to require their employees to listen to the speech. I want to be clear here that this is an area of these laws that is in dispute right now as to whether this is a limitation on employer of First Amendment rights to express their speech. The way I read the law, and I want to be clear that courts may disagree with me, and there is certainly room for other attorneys to have different opinions. This is a limitation on the employer's ability to require employees to attend these meetings. It is not a limitation on the employer's ability to have these meetings, as long as they're voluntary for employees. Whether that is a violation of the First Amendment is something that folks would debate, but I think it's a limitation on the sort of manner in which you can have these meetings, so they can't be mandatory, not a limitation on what you can say. I don't think there's anything in this bill that prohibits an employer from saying, we've invited in like this candidate for our Congress, employees are welcome to attend, but they're not required to. Versus we've invited in this candidate, all employees are expected to be there. We will be taking attendance.
And I know it's not always helpful to delve into hypotheticals, but in terms of requiring, if an employer has a political poster or a flag favoring one candidate hanging by the front door of the business, and that's where everybody comes in, is that where does it, how is that applied? Does it touch this?
So I think there's an argument there that the employer is offering communications about a political matter for which the participation of the employee is voluntary. I think there's also an argument that because you put it at the entrance to the business, there's no way for employees to avoid viewing it. I don't know where a court is going to come down on that. But I think if I were you could argue that they're not requiring you to, arguably anytime you put up a sign, that's communication. So, if you fly the flag of your candidate or a big poster promoting your candidate or whatever it is, you paint the side of your building the way, you've seen the farms painted with like Kennedy and 60 Yeah. So, where like the roof of the barn, you can kind of still make out the letters. Like, there's nothing that prevents a business from doing that I see. I think you're going to get into potentially some gray area over when it's an employer communication versus when it's not, and when an employee is required to view it versus when they're not. On those sort of, that's, you've asked a hypothetical that falls squarely into, I think you can make an argument either way. I have no idea whether a court is going to embrace one side or another. To me, I think there's a pretty good argument that that's not a mandatory communication. It doesn't have it's not like an email with a read receipt or a requirement that all employees participate in the forum on Tuesday or attend this meeting. So there's no coercing employees into viewing that. Although arguably, employees have to walk by it every day. Theoretically, they can look the other way. So I don't know where that falls.
And point of the very first section, little a, is not so much, again, that an employer can't display these things, and there's certainly things in the exemptions that go to the heart of the specific parts of the religious exemptions in particular, but it's about penalizing or otherwise discriminating against employees who don't want to participate or hear that meeting. They want to have a voluntary choice over whether they go to that meeting. So it's not, again, it doesn't, to me, a banner being hung, whatever it is, could be part of the business. It's just saying, if that employer, and correct me if I'm wrong in this interpretation, it's like if the employer says, we want to have a meeting that talks about this banner and what it means to us as a company, why it's important to us, and we want you to come, or we're mandating you to come. Number one, we can't mandate it, makes it a voluntary thing, but I'm not going to penalize you for not going.
Right. Yeah. So if it's simply that I've got this communication, I've got this opinion that I want to share with you. And I mean, if we get into the collective bargaining realm here, what this would say is okay, as the employer, when there's a union drive happening, what this would say is okay, is the employer can have a meeting where they say, we're going to talk about the union drive and why we oppose unionization in the workplace. Attendance is voluntary. Employees will be paid for their time, whether they attend or not, and no one will be penalized for not attending. So that is permissible under this bill. What's not permissible is saying you must attend this meeting where we're going to talk about why we oppose the union. So if we put that in, and then if you don't attend, you're going to be disciplined for, violating work requirements or whatever it is. And it gets more complicated than that because there's all sorts of fair labor practice requirements under the NLRA. But this piece here is basically saying you cannot have that meeting and require attendance and penalize employees for not coming. What you can do is say, we're going to have this meeting where we express our opinions. Come if you want to. But if you choose not to come, no one's going to be penalized for it. That's what this permits.
Thanks. I was trying to discern, thinking about a banner and how some messages, and we'd also have talked about the right to misinform, basically, but also, the
message behind some sentiments or political posters. Those could, like, that's not what this is talking about. That can fall under creating a hostile work environment or be addressed in other areas of law, right?
So,
Where does that
Um,
overlap?
so, I think what there are a couple of different things here. One, the NLRA protects against coercion by either the union or the employer through threats of violence or economic harm and other things. That is an area that is in a great deal of dispute that continues to this day. What is a threat of economic harm? What is not a threat of economic harm? One of the areas that has been in dispute is to what extent are captive audience meetings a form of coercion that contribute to a hostile work environment, like discrimination. That's covered under discrimination law.
That's what I meant.
So,
I've got
and
it.
this doesn't affect that at all.
That's what I mean. I'm just clarifying. I've
Yeah,
got in my notes here, captive audience, coercion or penalty are keys. Political or quote unquote political or quote unquote religious affiliation is key.
yeah. So if I were an employer and I had a meeting, voluntary or mandatory, at which I made discriminatory or derogatory statements about certain employees on the basis of their religion or their race or their gender or gender identity or sexual orientation, or national origin, any of those things, that's covered by discrimination law. And it doesn't matter if it's voluntary or mandatory.
Right.
This is specifically dealing with the right of an employer or not to have a mandatory meeting or a mandatory communication with employees that expresses the employer's opinion on political or religious matters. It also specifically in B, it does not limit your rights of action under other laws. So, for example, you could have a mandatory meeting to discuss religious matters at which the employer also expressed religiously discriminatory language, singling out certain employees that don't align with their practiced religion. There could be claims, if this passed, there could be claims under both laws because you had a mandatory religious meeting where employees were threatened with discharge if they didn't attend. And you also had a hostile working environment created through religious slurs being used at the meeting that were directed at certain employees. That's a worst case scenario. And this law wouldn't preclude you from bringing a claim under either or both laws. That said, you could also have a voluntary meeting, which doesn't violate the provision that's proposed in front of you right now, where the employer used religious slurs, and that would violate anti-discrimination law by singling out certain employees in the workplace and using slurs to describe them, or negative stereotypes or whatever it is about their religious affiliation. And that could create a hostile working environment that's actionable under existing law.
That is exactly what I was asking.
Great.
Thank you.
Okay,
That's the first time we've done.
great.
Well, yeah, I know, I'm sorry, can I,
Yep.
yeah, I'm
Yep.
so sorry. And
It's okay.
just because it's very much in alignment with that, and,
We haven't even gotten to the complicated part yet.
okay, I'll hold it.
No,
I will-
go ahead.
Okay,
Um,
so I just want to be clear that this is not saying that employers cannot hold mandatory meetings, it's just the context of like, so if it's a mandatory staff meeting, it's the context and penalization. Those are the key things. That's what,
Yes.
okay, that's it. See, look, I was easy.
You can have mandatory trainings. You can hold trainings that are mandated by law. You can have a mandatory staff meeting where you discuss the business of the week.
Right.
You know, so, for example, a store owner could have a Monday morning staff meeting where they discuss what products they're going to be pushing that week, how sales went last week, provide coaching to all of their staff on how to sell the new, gizmo or gadget that they just got in. Something like that, to meet with a vendor, to talk about the latest, greatest, whatever it is, talk about issues they're having with the freezer and back. You can have those meetings. What you cannot do is have the mandatory meeting where you say, this is our opinion on this political issue, this political candidate, unionization, and you have to attend or you're going to be penalized.
Right. Okay,
So,
thank you.
all right. Thanks, everybody.
Sorry, sorry.
All right. Getting back to the bill in front of you. So nothing in the section limits your right to bring a civil action for wrongful termination or limits your rights under an existing collective bargaining agreement or employment contract or one that you enter into. You keep those rights. Nothing in this section would prohibit a religious organization from communicating or having meetings regarding its opinions on religious matters. When you go to work for the Catholic Church or a religiously affiliated school or a religious charity, you are acknowledging that you are working for a religious organization and they have a specific opinion on religious matters. This law does not preclude those religious organizations from communicating that opinion to their employees.
But a commercial enterprise.
But so yes, a commercial enterprise that is not a religious organization.
But that may be controlled by.
So imagine you have, yes. The flip side of this is, so take a family-owned corporation where the family that owns it is a devout member of a specific religion. Doesn't matter what religion it is. They cannot have a proselytizing or other meeting with their employees where they share their views on the religious teachings of their organization and make it mandatory. They can always say there's voluntary, we have a voluntary Friday afternoon prayer session or a session where we teach about our religion, whatever it is, however they practice their religion, provided that there is no penalty for choosing not to attend, and no sort of like coercive benefit for attending. That would make it effectively penalize people who don't attend. So that they're allowed to invite people to join them in their religion. They just can't mandate it.
So again, as a school that is operated or controlled is exempt, or these are allowed. Again, even a nonprofit organization that's considered charitable,
right?
For a particular religion.
Right. So you work for the charity wing of a particular religion, whatever it is, that you're still expecting at that point that you're going to get religious communications. They're going to talk to you about religious holidays, about the tenets of their religion that drive their charitable work. That's something that you've signed up for by working with this group that is aligned with and affiliated with this religious entity. Similarly, D provides the same thing for political organizations. You are working for a political party. You are working for a registered lobbying organization that lobbies on political issues. So, and this could, so that basically you're working for a group where your job is to advocate or their job is to advocate on behalf of their organization on these political issues. Or they are a political party themselves, whether that, or they're a political candidate or a politician. In that case, you have an expectation going into that job that your employer will communicate to you about their opinion on political matters. So they are exempt from the limitations on these meetings because that's part of your job is to communicate, or at least part of the organization's mission is to communicate on these issues. So that's why the organization exists. This is different from, again, a corporation or some sort of business entity whose primary business is, let's say, selling widgets or producing gizmos or whatever it is. They also may have very strong opinions on political issues that affect their business. You see the difference, though, is that they are not an organization that comes into where their primary business is coming into the State House or Congress or City Hall, what have you, to communicate about specific political issues. So that's the difference here. Look at, is this a political organization or a political party? And again, in those cases, political communication, not religious communication. The one area where you may see overlap is if you have the political advocacy branch of a religious organization. So they may have, in that case, you're looking at someone who probably qualifies as both a religious and a political organization. And they can communicate to you about their religious opinions, which inform their political opinions. Sure. Vice versa. The final thing is that it doesn't prohibit employers from communicating information to employees that the employer is required to communicate pursuant to state or federal law. That is necessary for the employee to perform the employee's job functions or duties, or from requiring an employee to attend a meeting to discuss issues related to the employer's business or operation when the discussion is necessary for the employee to perform their job functions or duties. And then finally, from offering meetings on religious or political matters when attendance is mandatory. So if you have mandated training that state or federal law requires you to conduct, nothing prevents you from conducting that. That's essentially exempted from this law. If you have mandated postings in the workplace, that is exempted from this law. That is not mandating communication on a political issue, even if that posting is mandated because of the political process at the State House. That is required by state and federal law, so it's excluded. An employer is not going to get in trouble for doing that, and an employee will not have a claim for having to view, if, for example, we've passed laws in recent years that have said an employer shall provide notice of this law to all employees within 30 days of the employee commencing employment. That is not going to get an employer in trouble for complying with that requirement. So that exemption is put in there expressly to prevent someone from saying, well, I didn't agree with that law and you sent this to me, so I'm going to sue you for it. Okay. Yeah. So that the last provision in there is the penalty and anti-retaliation provisions. It's the same enforcement and anti-retaliation provisions as it applied to our other non-discrimination laws. But it does bring us to some of the important things to discuss with this, because these laws have been controversial. They've generated lawsuits. There is currently, and I have to correct the record. When I walked through this the first time, I said that this could generate a preemption controversy, but that I wasn't aware of any, and I misspoke. There have been cases in Oregon, and there is a pending case in Connecticut that I'm aware of. I understand that there may be action elsewhere as well. That's just what I happen to be aware of. The case in Oregon was decided on standing grounds. We're not going to spend a lot of time on this, but just so you understand, in order to get your case into federal and state court, in most cases, you have to be able to show that you have suffered an injury in fact, or are likely to suffer an injury if the law goes into effect. You have to show that the injury is traceable to the action that you're challenging by the defendant. So whatever the defendant's doing, you have to show that it goes to them so that they're a proper defendant, essentially. And then you have to show, and this is very important, that the court can issue a decision that will fix the injury you're alleging. So sometimes you're alleging a harm that the court can't fix. They can't provide you with a remedy. Sometimes you're alleging a harm that isn't traceable to the defendant that you've brought into court. The defendant isn't responsible for the harm you're alleging. And sometimes you brought in a defendant, it's the proper defendant, but you can't actually show that you've been harmed by the law. In the case in Oregon, the issue was that the organizations that brought the case couldn't show that they were actually harmed by the law. So they didn't even get to challenge it. You don't get to challenge a law if you can't show that you're harmed by it. So the case in Connecticut revolves around two claims. One is that the prohibition on captive audience meetings violates the First Amendment rights of employers. The second is that it's preempted by the National Labor Relations Act. That case has proceeded past the initial motion to dismiss. That doesn't mean that it's going to prevail on the merits. It simply meant that the court said, I think that with respect, and the court very helpfully didn't issue a written decision. They decided this in a hearing and then just issued a docketing statement, which told us only that they had granted the motion to dismiss with respect to the Department of Labor, but not with respect to the Commissioner of Labor and the Attorney General. So that just means that they're allowing the law to proceed so that they can decide the merits of the First Amendment and the National Labor Relations Act claims, not that they've decided that. I do not know how long it will take for that lawsuit to make its way through the court, or how long it will take to get a clear decision on this in either the Second Circuit or at the US Supreme Court level. Because remember, those are the two federal entities that apply to us here in Vermont. So to give you some background on captive audience meetings, the argument is that captive audience meetings, or at least the arguments that's being advanced by the plaintiffs in the Connecticut case, are that captive audience meetings are expressly permitted by the National Labor Relations Act, which under 29 USC 158C, you don't have to remember that, permits employers to express any views, argument, or opinion, whether in written, printed, graphic, or visual form, and says that that shall not constitute or be evidence of an unfair labor practice under any of the provisions of this subchapter, if the expression contains no threat of reprisal or force or promise of a benefit. So in other words, no coercion. So the argument from the plaintiffs in that case is that the National Labor Relations Act expressly permits employers to express their opinions on unionization. So their argument is basically any speech by a company or its officers is protected by the NLRA and arguably also the First Amendment. The argument by the defendants in that case is, yes, you're entitled to express your opinions on unions. This law doesn't prevent you from doing that. It prevents you from requiring employees to listen. I can't tell you where this is going to come out on that issue. It's a pending case. There are two types of preemption that are at issue here. I'm going to try to make this really simple because preemption, like I said, is this incredibly complicated and nuanced topic. But there are two types of preemption. One is called Garmin preemption, which prohibits states from regulating activities that are protected or prohibited under Sections 7 and 8 of the National Labor Relations Act. Section 7 is the section that permits employees to form a union, to bargain collectively, and to engage in other concerted activities for mutual aid or protection in the workplace. So this can be talking about wages, talking about working conditions, asking your employer to improve working conditions. Those are all protected activities. Section 8 simply regulates what are unfair labor practices. It makes it illegal for employers and unions to restrain or coerce employees in exercising their right to join or not join a union. And it provides a federal cause of action for claims that someone has engaged in these coercive or unfair activities in relation to bargaining. It includes other things like a requirement that the parties bargain in good faith once you've formed a union, et cetera. And that cause of action is one of the keys here. It basically says that when there's a dispute over whether a meeting is coercive, it should go to the National Labor Relations Board. It shouldn't simply be prohibited by state law. What the court's going to be looking at is, does the state law in Connecticut, and if you choose to enact it here in Vermont and it gets challenged, they would look at, does the state law, does this bill in front of you, does it intrude on that federal area of regulation in a way that interferes with the federal scheme? So that's Garmin preemption. Basically, think of it this way. Does something in here contradict and interfere with what the federal law says? The machinist preemption is a little different. That basically forbids the National Labor Relations Board and the states from enacting laws that would regulate something that Congress chose to leave unregulated. They like to say the free play of economic forces in courts, but basically it's where Congress said, we're leaving this out there as something that we're not going to regulate. So one good example of this is peaceful conduct by unions in an effort to gain a concession from an employer. So there was an example of this where there was a dispute over overtime between an employer and the union told its members to not work any overtime while the dispute was pending. And when this was challenged by the employer, the court said, no, you can't enter an order requiring the union members to work overtime. This is peaceful conduct that Congress chose to leave to the unions as a self-help mechanism. This is not destroying employer property or other violent or coercive conduct that they specifically prohibited. This is a peaceful way for the union, similar to going out on strike or picketing or doing a boycott or something like that, where Congress said, you're able to do this. And so you cannot have a state law or a federal law or a federal ruling from the NLRB that intrudes into that area that Congress said, we're going to leave this up to the economic forces at play there. So the question here again would be, is this intruding on something that the Congress intended to leave open to the free play of market forces? I think more likely than not, it's the first type of preemption that you'd find here. Is this interfering with the federal law that permits employers to communicate with unions regarding their opinions on unionization? I don't know, like I said, how a court is going to come down on that. To date, none of these lawsuits have succeeded, with the exception of a lawsuit in Wisconsin where the district court ruled in favor, and the state chose not to pursue the appeal because of a change in administration to an administration that was expressly anti-labor. So they chose not to pursue that law at that point, and the case dropped there. In the other cases, it's died on standing. The Connecticut case is an outlier. So this is not to say you can or can't enact this. This is simply to say that there is a chance that this would be challenged. And there is a chance that if it is challenged, that a court could rule against it. I think you've heard arguments from your advocates on both sides. And I simply don't know where the courts are going to come down. The Second Circuit tends to be more favorable to unions. The US Supreme Court currently tends to be less favorable to unions. But again, none of that is a guarantee for how this case comes out.
So in the case of like Oregon, the law is in effect.
The law is in effect, and it's been in effect for more than a decade now. After that initial challenge,
It hasn't been challenged on any of these potential grounds.
right? One of the arguments in the current case in Connecticut is that it's the challenge, they haven't actually alleged any concrete injuries. The court let them stay in the case, so it denied the motion to dismiss on that ground. But that may be one of the factors in actually determining whether there's an injury here, whether this is actually infringing on their ability to provide their opinion on a union organizing effort, or whether the flip side of it, it's simply saying you can't make employees listen to your opinion through coercion.
And from a legalistic perspective, again, getting back to standing, the issue so far has been that, just reiterating, I think what you said earlier, is that these cases have been brought forward and all of the motions that have been done up to this point are using hypotheticals rather than hypotheticals made by larger organizations, as opposed to, there was a recent case about the cake shop in Virginia, I believe, but even that was a hypothetical situation about whether or not an individual has to sell a cake to a person I don't agree with.
Right. So it was Colorado, the cake shop. And in that case, you were talking about an individual who believed that same-sex marriage was morally wrong based on their religious beliefs. And they wanted the right to refuse service to same-sex couples. Their job, they made wedding cakes. That was what they did for a living. In that case, the Colorado equivalent of our Human Rights Commission found that they had violated the state's public accommodations law. They, in addition, made some very unfortunate comments on the record regarding the person's religious beliefs, which made it clear that they were targeting the person based on disagreement with their religious beliefs. The Supreme Court ruled, one, clearly this was basically flipping discrimination, where they were discriminating against someone because they had disfavored religious beliefs. And then two, that in either event, your religious beliefs are protected under the First Amendment. So you cannot require an individual or business to do something to engage in expressive activity, such as decorating a wedding cake, that would conflict with their religious beliefs. So in this case, they ruled in that case that that expressive activity was protected by the First Amendment, and that they could not require this person to associate with or do business for individuals who conflicted with their religious beliefs. This is a little bit different, because what we're talking about here is primarily statutory law. Generally, courts will try to decide a statutory issue before they get to the constitutional issue. We have this doctrine of constitutional avoidance, where if we can avoid the constitutional issue, we will. And you only decide on the basis of the Constitution if you can't avoid the statute. What we have in the National Labor Relations Act is two pieces that are in tension with each other. One is this prohibition on using coercion. And you see it in that language, that 8C language, which bars, which permits employers to express views, arguments, or opinions, provided that there is no threat of reprisal or force or promise of benefit as part of that. And then there's an express prohibition on coercing or threatening individuals with respect to joining or not joining a union. So what you see in tension, and it's in tension in these captive audience meetings, is the mandate of the meeting coercion and violation of the NLRA, and therefore these laws are in alignment with the NLRA? Or is it an employer expressing their views as protected under the NLRA, and therefore these laws are in violation of the NLRA, and they come into that direct conflict, so they become preempted by the federal law? If you're in alignment, there's no preemption issue. If you are in conflict, there is a preemption issue, and then the federal law would prevail. That being said, getting out of the NLRA issue, there is this secondary First Amendment issue, where the question is, are you limiting an employer's right to speak on an issue in a way that violates the First Amendment, or is this simply a reasonable regulation of how you can speak? So that's sort of the secondary issue. The piece to remember with this too is that even if the labor relations piece is struck down, we do have a provision on our books that basically says that to the extent the rest of the law can be preserved, that will stay on the books and stay in effect. So your captive audience meetings on other political and religious issues would still be prohibited unless you could show that they were unconstitutional across the board. So there's two pieces here. Even if you were challenged on preemption, the law might still stick on everything but the union grounds if the preemption claim won the day in court. So there is a lot of if going on here.
Right. So our decisions will end up being what do we want to do?
Right. At the end of the day, the decision comes down to what do you think is the right thing for the statute here? And you just should go into it with open eyes, knowing that it may get challenged and that there's two different challenges that are there potentially, but that there's no guarantee whether a court is going to either strike down or uphold the law. And if they do strike it down, it may just be with respect to a very narrow part of it. Okay.
Okay, that takes us through section 1, right?
And that brings us to card check.
And we're gonna stop here.
Okay.
Because it's that time before lunch that if we get involved with this, we're either gonna fall asleep or work until 2, and I think we'd rather have lunch. I just prefer to keep this, so we did 2 sections of the bill today. Damien, we're checking to see your schedule to see if you're available after the floor, which should be short today. It sounds like
you're an institution.
I am, we're marking up the capital bill.
okay. So,
And tomorrow. Or is,
like,
well, yes, and no, we have non-serialized.
Ghost guns.
The speaker's office is saying there's a 65% chance that the floor will adjourn by one. But again,
I'm sorry, there's a what?
a 65% chance that the floor will adjourn by 1 p.m. tomorrow. For meeting time.
That's from the Office of Legislative Statistics.
Yeah, I thought it was the legislative weather forecast. And also forecast high winds throughout the morning in the House chamber.
That's not. Those aren't.
Good one.
Those aren't outrageous. Anyway,
So for tomorrow, I again am tied up in the afternoon on the Capitol bill and Senate institutions. They're trying to vote it this week so that it can get through the appropriations committee and then make it back to this body in time for conference committee.
so committee, let's meet 10 minutes after the floor today and just check in and we'll see where we are with. We may not have work after the floor this afternoon. That we can certainly have a conversation. And if we do, we'll put it on the schedule as such, about what we heard last night and perhaps on. Yeah, I mean, we have time for tomorrow, I think, scheduled. I'm sorry, Ron, I haven't memorized my. We have time tomorrow.
Time on 102 committee time after the floor and in the afternoon, just not sure when that would actually be.
On our schedule for this week, Prop 3 is we have a discussion tomorrow after the floor, but we can shift that to today as well. So why don't we plan on that 10 minutes after the floor, we'll have a recap session on Prop 3 from last night.
Okay.
And then we can, again, the next steps to that.
Sorry for interrupting your walkthrough with so many clarifying questions.
This is what this walkthrough is for. No, Representative Lamont, this is exactly what this kind of walkthrough is for. We had this walkthrough. We've had testimony, we've had education, now we have a different context and a better understanding of the vocabulary. So the questions today were much different than they were 3 weeks ago. And that's what, again, that's the process I like to go through. We haven't identified anything that stands out from a writing perspective. We're just doing subject perspective. And then the next time through this, by the time, perhaps by the end of next week, we'll have gone through it in markup phase. But this is prelude to each one is a step further down. And so getting this explanation now makes more sense than it did a few weeks ago.
Yes.
I hope. Because it's in the context of, but it's also, as Damien pointed out, we're moving from the surface level into some deeper issues. And I think this is all very helpful. And then we're going to snap back to what the bill actually says and not, we can do the rest of our work in terms of what potential outcomes could be or consequences could be, but it's just part of our process. So thank you, Damien.
Thank you so much.
You're welcome. And please always feel welcome to ask questions. Don't hesitate.
Well, because it just gets so wordy. So like, I just try to ask questions to simplify my brain because I start going all zigzags. I'm just like.
Yeah.
Simplify the language. Okay, I understand this correctly. Thank you.
And before we go, sorry, there's just, Liz Medina shared a thing that's been posted on our website. It's testimony, from 2022. It's an act protecting the employee freedom and conscience. I believe this is about Connecticut's law. So
I think it addresses some of the constitutional preemption issues that were brought up. That'll be helpful.
Thank you.
And you know, the witness was Greg Becker from the AFL-CIO. So just read it, and it's there as a resource for us to look at. All right, thank you, everybody.